Welcome back to Fossil versus Future. I'm Daisy.
And I'm James.
And today we're going to talk about what about law? Environmental law is the law relating to environmental problems. But as we know, these problems are anything but simple. They involve many different people, changing physical conditions, diverse socio-political values, and often limited knowledge. Traditional legal doctrines weren't designed with challenges like climate change or biodiversity loss in mind, making environmental law a uniquely challenging and evolving field. Because environmental problems are so diverse, environmental law is diverse too. The environmental law of one jurisdiction isn't necessarily related to that of another, and national systems don't exist in a clear hierarchy with international law. Each environmental issue presents its own challenges, and so the legal responses must differ as well. These responses range from multilateral international treaties that create frameworks for collective action, like the UN Framework Convention on Climate Change, to national legislation to control pollution, and court judgments to set precedents, resolve disputes, and interpret legislation. Environmental law also draws on tools like emissions trading systems and landfill taxes, legal behaviours designed to influence behaviour through markets and incentives. Environmental lawyers work at the intersection of law, science, and policy. Their job is to apply and adapt a range of legal concepts to environmental problems, many of which require entirely new ways of thinking. We are thrilled to have Professor Philippe Sands with us on Fossil versus Future today. Philippe is Professor of Public Understanding of Law at UCL, visiting professor at Harvard Law School, and a practicing barrister at 11 KBW. We could fill a whole episode with Philippe's achievements. He has written 18 books and been involved in many significant international cases, as well as frequently advising governments, international organisations, NGOs, and the private sector on all aspects of international law. In his latest book, 38 Londres Street, Philippe gathers the threads that connect Chilean dictator Pinochet to a fugitive SS officer. We've mentioned Philippe quite a few times now in previous episodes, for example, his work with James on the legal consequences of the Chernobyl accident and prior to the Rio summit, and his leading contribution drawing up the definition of ecocide, which, in fact, I think might be the topic of his next book. But we can talk more about that. Philippe, thank you so much for joining us. Wow, where to begin?
Let's begin by saying how incredibly happy I am to be with you, my dear, dear, dear friend James, and of course you, Daisy. And let's have a substantive and fun conversation.
Can't wait.
It's good that the beginnings connect us, don't they? I mean, the first work that you did on Chernobyl, on law and communications, I remember it very well, and going off to Washington for you to give a speech, and me also to give a paper on sovereignty, I seem to remember, and the things we learned because a satellite tracked and monitored the radionuclides coming out of Chernobyl, and it was crossing boundaries, and we could see that there was a transboundary effect from the accident, but the legal system wasn't really coping with it very effectively, and countries paid compensation to their farmers, and like we did here in the UK when sheep had to be destroyed up in the Shetlands. I think that was one of the examples. But the international legal system really struggled to deal with any normal claim for the loss and damage arising out of the accident, and it was in the days of the Soviet Union, and the system didn't function very well. And then after we did our various speeches in Washington, we all went off to the Tabard Inn in DuPont Circle with Durward and Wendy, and there began at least the first discussions which led to the Centre for International Environmental Law, which we founded in 1989. So there's long history here, and you with your teaching, but also your writing and the cases you've done and the negotiations we've done together on climate, and now with the kind of resurgence of the idea of ecocide, which brings together your work on international crime as well as the environment. It's a very nice convergence there. That means that we've got a lot to talk about, and maybe just as a sort of starter for where this might go. Lots of questions about the effectiveness of international law, in a time where it's really under threat, where there's a huge nationalist, populist challenge to multilateral institutions, where there's a kind of disregard for the rule of law emerging in many places, powerful places like the US, and where extra effort needs to be expended to hold on to the legal structures that give us an opportunity to confront abuse of power when it relates to these classic environmental problems, of which climate change probably looms largest. So those are the sort of things I think we ought to talk about, as well as
let's go back to the beginning, because I think it's important. Firstly, we're focusing on the international side, and we're not focusing so much on the domestic law side, which has a much longer history. But 1986, April, the Chernobyl accident. I mean, there wasn't such a thing as international environmental law. There was no textbook. I was not taught it at university. I'd been just 4 or 5 years earlier. There were no courses on the environment. In international law, it was not part of the syllabus. In our international law textbooks, there was the word environment did not feature. Chernobyl changed everything. It was an absolute game changer. I remember in the early 1990s, after we'd been through that initial period that you've just mentioned, having a conversation with a renowned professor of international law, Ian Brownlee, and asking him why he didn't have a little section on the environment in his famous international law textbook, Principles of Public International Law. And he said, because the International Court of Justice has never addressed the environment. That conversation was about 1992. And then 4 years later, there was a case before the International Court of Justice for the first time, what's called an advisory opinion from the UN General Assembly on the legality of the use of nuclear weapons. And I'd been counsel with others for a group of small island states from the Pacific who argued that in assessing the legality of the use of nuclear weapons, you have to also consider their impact on the environment. And I remember the then British Solicitor General Nicholas Lyle saying that these arguments were nonsense and dangerous nonsense. But the International Court of Justice, in its wisdom, at paragraph 29 of its advisory opinion, stated, and this was historic, that the protection of the environment is now part of the corpus of international law. And with that decision in 1996, I think international environmental law really began. Ian Brownlee, in his next edition, did include the environment, a sort of minuscule 4 pages out of more than 1,000 on the environment, but subsequently it has built up. And I think no one today denies that there is this body of rules called international environmental law, made up, as Daisy said, of treaties and other intergovernmental decisions, and also rulings of international courts and tribunals, and many, many writings. And so we are in a different place, and 40 years on, that body of rules is there, it's vibrant. In large part, it works very well, but of course there are areas where it has not succeeded. The successes, of course, include on ozone, the Montreal Protocol on the ozone has absolutely succeeded. It's a remarkable achievement that countries come together and actually they ban the use of the emissions of chlorofluorocarbons and other things, and it has protected and saved the ozone layer. Climate change has been much more complex, and very frankly, it has not achieved the objectives that everyone had hoped for, but that's not to say it's been a complete failure. It has changed consciousness, and it will now be severely tested by a Trump administration that is committed to, burn, baby, burn. And that it means we're in a moment where these issues are going to be very severely tested. But I think, and I've always thought, international law across the board is a long game. You have to understand it's emerged in its modern form just in the last 8 or 9 decades. And these things take time to settle in. So it's a decades and centuries long project. And over time, I have no doubt that the rules will work their magic and have their effect. But it's not going to be immediate in all cases.
So what role do you think environmental law has in terms of solving climate change or contributing to solving climate change? What can it do and what can't it do?
Well, I mean, I think it has had. You can't say that the various rules. I mean, James has been much more involved than I have. I was only involved until 92, 93 in the negotiating of the Framework Convention on Climate Change. James has been involved across the board subsequently in pretty much everything. What it has done, what it did, was it put the subject of climate change onto the international agenda. It changed consciousness, and it has had an impact on the behaviour of humans and corporations. It has not had the full extent that some people would want, but the fact that people like me drive around in electric cars and travel in Europe now pretty much only by train, not by plane, all of that is a consequence of a change of consciousness. And these things, will over time continue to have a big effect. What we're going to see, I suspect, in the coming years will be those countries that remain committed to addressing climate change taking measures which will limit imports of products that are made in climate change unfriendly manner, and the United States will find itself on the receiving end, I suspect, of all sorts of difficulties. There will then be disputes between the World Trade Organization and other places. We are waiting for an advisory opinion from the International Court of Justice on climate change. It's going to come down imminently. I don't know how far it's going to go. My big hope for that opinion is that it will address the science and just knock out of the park these really absurd arguments that there is no science behind climate change. Beyond that, I'm not so optimistic about what the opinion will do. But it comes back to the simple point. It's a long game. You've just got to stick to the science and keep batting.
One of the things that we've talked about in previous episodes is very evident in the framing that you've just done, is that law also shapes markets. Law provides incentives, punishments, penalties, ways of structuring and guiding economic activity, and that's sometimes stresses international institutions that have those competencies. I mean, the WTO is not a strong institution at the moment, and although it has a very vital role to play, has always struggled with the connection between environment and trade and economy. There will come a point where these institutions really do earn their corn, because the disputes are going to increase. The European Union, as you know, has tried very much to make that point that you just made, that there will be a price if you want to export into the European Union and you don't regulate greenhouse gas emissions. You're effectively subsidizing your industry, and you're placing the burden of dealing with the problem on everybody else, right? With a single atmosphere, it doesn't really matter where you emit your greenhouse gas emissions, but it really matters that there's some cohesion, some collective will to solve the problem. So if you are not, you are free riding on everybody else. So that it's quite proper for a country to say, well, we're going to regulate, we're going to put a price on carbon, we're going to do something that our industry has to comply with. So if you want to export into our markets, we'll equalize the cost at the border, so-called border tax adjustment. It's just really hard to do in practice. I mean, it's nice for politicians to declare we're going to do that. It feels strong, and it's logical and economically rational, but it's hard to do in practice. And so it will test our ability to do both, to reshape markets, to create the right incentive to deal with the problem, and law is very meaningful there, but also to settle the conflicts between competing objectives of society, trade-offs between economy and environment. You need robust institutions to do that, and at the moment they're either not very well funded, or they're not really supported in the way that we need them to be.
Well, I think it's a mixed bag. I think one of the challenges that we have right now is that as a society and in our media, we tend to focus on particular issues to measure success or failure. But I think if we step back and look across the board, you begin to see that the environment in the international legal order has touched upon pretty much every single issue one can imagine. I mean, I've been involved in cases on a multitude of different issues. On the law of the sea, for example, the environment has become a significant part of legislation and adjudication and disputes. In one set of cases that I was involved in on the self-determination of Mauritius and the Chagos Archipelago, the question of a marine protected area and its longevity became a central part of the resolution of that issue. There's a whole other area that's sort of off most people's agenda, which is in a field called investor-state arbitration. Those are the rules in which foreign investors are given protections against inappropriate actions by the state, expropriation, unfair, inequitable treatments, discriminatory treatments. And in the field of investor-state arbitration, the extent of a state's right to adopt measures that limit, if you like, the profitability of an investment on grounds of the need to protect environmental protection has become a very significant issue. And I've sat in a number of cases, these are in the public domain, for example, in Colombia, where the protection of what are called paramos, high altitude, biodiversity rich areas, has come into conflict with various mining activities. And there are a series of rulings by investor-state arbitration tribunals which have gradually over time shifted the dial in favour of measures that are legitimate, that are proportionate, that are reasonable to protect the environment. And we see that across the board. These things are very often not in the public domain. The media doesn't talk about them, doesn't write about them, doesn't, look at the headline issues of climate change and so on and so forth, but takes its eye off many of the other areas where the environment is beginning to infiltrate. Even in the field of international criminal law, there's a tremendous debate right now as to the capacity of the International Criminal Court to deal with environmental crimes. I happen to believe the capacity of the ICC to deal with environmental crimes is limited to virtually non-existent. But the prosecutor of the International Criminal Court has decided to convene a consultation on how you interpret and apply the rules of the International Criminal Court statute, war crimes, crimes against humanity, genocide, the crime of aggression, to better protect the environment. My own feeling has been that the rules can't adequately deal with the environment. What you need is a fifth international crime. You've mentioned it at the beginning, ecocide, and it's contested. But the fact is, there's a debate about it. And the fact is that in December, a group of countries, last December, formally proposed the amendment of the Rome Statute for the International Criminal Court to include the fifth crime of ecocide, on the basis that minor tinkering of existing rules is neither here nor there. So even there, it's beginning to have its effect. And I think that if you step back and look across the board, you'll begin to see that the environment and the notion that the environment needs protections under law, under international law, has seeped into pretty much every single area. And if you go back to the beginning 40 years ago in the 1980s, when James and I got starting, that I think would have been unimaginable. So this is a very significant change of consciousness and practice and effect that has taken place. That's not to say the environment has been saved. That's not to say we have gone far enough. I've just written a piece in the Financial Times, a sort of review essay of a wonderful new book by Robert Macfarlane called
He's just mentioned it on an episode.
Yeah, is a river alive? It's an amazing
Fantastic
book that essentially builds on the single law review article that I cite more than any other, the best law review article ever written by a wonderful person called Christopher Stone, an American academic, who in 1972 published an article, Should Trees Have Standing? And he posits the idea that just as we have rights for corporations, we should also have rights for natural objects. And he's right. And my review in the FT was glowingly positive of Robert's book. And I think we've missed a beat. We've adopted an approach that's basically much too anthropocentric, whether it's human rights or climate change or the crime, or the criminal order. We're excessively focused on the well-being of humans. And I think the next stage in the change of consciousness is to recognize that the well-being of the planet is not limited to the well-being of humans. And the international legal order needs to shift its focus onto giving rights for natural objects as an end in itself and not merely to protect us, the human.
Yeah, we've talked about it before, haven't we, Daisy?
Yeah, I think so. So in terms of in a practical sense, I'm just trying to imagine an example, is that if you polluted a river, you could get punished by the law as a result of polluting that river because of the damage it's done to the ecosystem rather than the damage it's done to the health of people, for example.
Sure. So let's take an example. So I've got a hearing coming up at the end of this year or beginning of next year in which one country, the Gambia, has gone to the International Court of Justice to protect the rights of a community, the Rohingya community, against behaviour that is alleged to be genocidal. So the parallel would be to imagine a situation in which a country could go to the International Court of Justice and bring a case against a country or more than one country that was causing harm to an environmental resource, to a river, to the climate system, to the atmosphere, to an area of ocean, not to protect humans, but simply to protect that natural object, that environmental resource. Now, that has not happened so far, but my prediction, I make it clear, is that with 100% certitude, that's going to happen. 50 years ago, people said the idea of going to an international tribunal to protect the rights of a community from human rights violations was unimaginable. I remember having a conversation with a wonderful American jurist called Thomas Bergenthal, who was a judge at the International Court of Justice, but as a 10-year-old boy, he was a prisoner at Auschwitz under the care of Dr. Joseph Mengele. And he said to me, can you imagine, Philippe, in 1944, there had been a piece of paper that was called a treaty, and that treaty allowed another state far away from Germany to go to an international court and say, you cannot treat us like that. You are subject to limitations on the way you can treat these children. It's the same thing. And I think that's the way the legal order is going. But we need to have some sort of a mighty leap, which Macfarlane and Stone and others of their ilk, Rachel Carson, one imagines, Bill McKibben and others, imagine as coming at a certain point of time. And I think we're moving in that direction. And the Ecocide project is essentially premised
Is a form of that. Yeah.
On recognising that the environment is something to be protected as an end in itself under international law, not simply to protect us, the human.
It's not simply the utility to us that it offers. But Daisy, there are plenty of laws and structures in our legal system to deal with the pollution of the environment per se. What is interesting about Robert's thesis and the wonderful Christopher Stone article all those years ago is that it takes it a step further than merely thinking about the effect of human activity on the environment. It's imagining that the environment is a participant in your legal process and has a stake in your legal process. And it requires some artifice, and we do this all the time, by the way. We have all sorts of structures in our legal system that represent those either can't represent themselves, or that's a fiction we have created in order to achieve another outcome. And there are loads of examples. Corporations themselves are legal fictions. The Attorney General is an office, not necessarily an individual. We have guardians ad litem. We have various inventions to help make a case that helps deliver a public good that we care about. There's nothing in our imagination that would prevent us from doing the same for a river or a mountain. Or if you go back into some other cultures, we've talked about this before too, Daisy, that celebrate other living organisms because they have a spirit attached to them. Or you think of the sacred groves in West Africa, which are animated places that have an existence that is separate from but respected by humans. I don't think we're far away from that. I agree with you, Philippe, and I think it would be very helpful for the law to achieve more of the protection of the environment from us, essentially helping us to help ourselves by recognizing that the environment is not just us.
How would it work for climate change, though? Because climate change isn't quite so direct as, say, polluting a river because one person releases greenhouse gases and the impacts of that are not direct. You can't really put one person's actions to the impacts.
Now it's a real issue, and we thought about that a lot when we were discussing the crime of ecocide. I mean, each and every one of us contributes to climate change. Does that make each and every one of us an ecocidaire? And I think the answer is obviously not. It's that certain actors cross a threshold in relation to the significance, nature, extent of the contribution they make to the problem. And the challenge will be to define at what point do you, as an actor, an individual, a state, a corporation, cross that threshold. And that remains to be determined. You can determine it by regulation or by legislation, or you can leave it to prosecutors and judges to determine on a case-by-case basis as to whether the nature of the act is such as to cross that line. But the law has means for dealing with that. It has notions of joint and several liability, where a number of different actors are responsible and contribute together to a problem. The fact that you haven't got all of them in front of you in court doesn't mean that one amongst them cannot be held to account. And that is established also in international law, and that is the way to go. But I think the challenge will be to determine when a particular actor on that issue of climate change has crossed a line. I mean, I've always thought that it's a very difficult situation to put judges in the position of making that determination. They need some guidance from the legislator to interpret and apply. And at this point, states seem unwilling or not yet ready to define where those lines should be. But I think it will come over time. So the simple answer is, in principle, that problem can be addressed, but it has not yet been addressed. Although I think those countries or actors who seem hell-bent on denying the existence of scientific consensus or science on climate change or any other issue do put themselves in a difficulty in terms of acting recklessly or sort of with wanton abandon in taking decisions that are going to be harmful for others. So we have the capacity to deal with this.
I think there's also a clear intergenerational element in both the ecocide discussion, but also in thinking through how you might use the law to situate human activity in the face of threatened ecosystems. I mean, obviously there's a gap, Daisy, isn't there? I mean, it's as you say, it's not so direct. It's much more a diffuse problem with climate change. But there's a lot that we do understand about the consequences of climate change on natural systems and on species who can't cope with small temperature rises or can't adapt fast enough. You know, we as a species, we can adapt quite well. Many others can't. We know the situation with corals and actually Robert Macfarlane's book is very good at explaining the connection between a living system and a human-made threat to it called climate change. Funnily enough, we also talked in previous episodes about the appeal of law to younger generations who are bringing cases before tribunals around the world. Lots of them, actually, some in the human rights context, some in the constitutional law context, because their rights to, that if you like, the rest of their life are being impaired by the climate change problem. But I think also, Philippe, as you mentioned, one of the reasons why young people are bringing these cases to courts and tribunals is because it gives them a chance to establish facts, to get evidence out there in a calm and rational forum, when outside the courtroom there are very powerful people with loud voices and a big microphone who are shutting them down or flooding the field with disinformation and powerful arguments for maintaining the status quo, which are hard to resist if you are not powerful yourself. So I think a lot of the cases, if you look at, and there are many, aren't there? There are many cases brought by young people. I quite like actually the combination of young and old. So you've got the Irish constitutional law case, which is sort of youth oriented, and you've got the Swiss grannies bringing their case. You can see the intergenerational connection very clearly in some of these constitutional cases that are being brought.
Absolutely. And it's not just, again, we're focusing on the international, but the international also has a role to play in the domestic legal order. And increasingly, cases on climate change and other environmentally focused cases are being brought in national courts on the basis of international laws, on the Law of the Sea Convention, on the Biodiversity Convention, on the climate change rules at the international level. And again, it's another aspect that bothers me, is that we tend in our reporting to focus on the cases at these high level international courts and tribunals, and we ignore at our peril what's going on in national courts involving international rules across the globe. It's a remarkable development that's taking place, particularly in the field of climate change, and it's one of the reasons I think that it's hard to focus on is there's so much of it. There isn't a single, shop to stop at and see the totality of what's going on. But there is sort of an avalanche of international rules being engaged in domestic legal contexts, including courts. And this is, I think, very, very significant. So
LSE have a team tracking this. They have a tracker on litigation on climate. Yeah, it's really amazing. The map is populated with cases.
Yeah. Could AI have a role in that? Bringing all the...
Well, what do you mean? Synthesizing what's... Yeah. Well, it's a good question. I mean, if you were to take all of those cases... Interesting project, Daisy. Take all of those cases and run them through a process to identify the causes of action, the percentages of success, perhaps. Yeah, you get quite an interesting model. These are sort of arguments that are working. These cases were brought by these people in these circumstances, and they were successful. Don't forget also, in certain type of litigation, you can win while losing. And you can bring a case, might be a stretch in the existing law, pushing the boundaries of interpretation of a particular rule.
Absolutely.
And lose, but establish that maybe the next case you might win, or that at least you've moved the position forward enough to resolve a real world problem or provide ammunition for a rule change, encourage a political procedure to pick this up and change the rules. These things can happen if you do litigation strategically and you have an end in mind and you persevere.
This is a really important point, James, and people often forget it, that if you look at the history of national, international legal orders, it is often the case that a single dissenting opinion has transformed the direction of the legal order. The most famous case that we learnt about at law school, Liversidge versus Anderson, Lord Atkin's statement that amid the clash of arms, the law is not silent, which basically said states were not free to use whatever methods and means they wanted in killing people. That was taken forward at the international level, a wonderful dissenting opinion by Judge Philip Jessup in the South West Africa case in 1966, determining that South Africa was not free to apply its apartheid rules as it wished on the territory of what was then called South West Africa, Namibia. And then much more recently, in 2015, a ruling of an arbitral tribunal in the Chagos case, when two judges out of five, two arbitrators out of five, Wolfram and Kateka, gave a joint dissenting opinion determining that Chagos was part of Mauritius, not part of the United Kingdom. That was a dissent in that case, but it became the majority within 4 years in a decision of the International Court of Justice. So the lesson, particularly for young listeners who might be feeling a little bit disillusioned and disenchanted with the state of the world right now, is just keep going. You just stick to your principles, you stick to your guns, you make your arguments, and even if you don't prevail completely at this point, if you get one or two judges on side, there's a fair chance that with the passage of time, it will change. I mean, I had that experience in a series of cases that I sat on the Paramos in relation to, high altitude biodiversity protected areas in Colombia. The first ruling, I dissented. I was in a minority. The second ruling, in terms of the protection of the environment and whether there'd been a violation of the relevant treaty, the second ruling, I was in the majority. It was a 2-1 decision. The third ruling, which I didn't sit on, was a unanimous decision that adopted the dissent that I had done in the first case. And so we see that over time, consciousness changes, rulings change, and I think that there's plainly a generational thing here. The judges who are sitting in international cases today are very largely people like me and James, who never studied the environment at university, for whom we're late comers. But the new generation of judges who are on the cusp of sitting, if they're not already sitting, are, people from across the globe who actually studied the environment at an early stage and started to think about the environment at an early stage, even at school and then at university and then subsequently in their practice, and for whom the protection of the environment is a central part of their juridical thinking. So it's plain what the direction of travel is. We've not yet crossed the line where that has become part of the established order and the norm, but it's going to happen. There's no question it's going to happen. And it's just a journey that is being taken right now that leads, I think, only in one direction. And that's one of the reasons we see in certain countries a backlash. They don't want this to happen, but what history shows us is these backlashes are generally short-lived. They don't fundamentally change the direction of travel, and my expectation is that those countries that are committed to burn, baby, burn will find themselves in a minority and fizzling out over time. But I think what we also learn is that it takes some major disaster to really concentrate the mind, and I fear that that is what it will require in the environmental field, whether it be climate change or biodiversity or other areas. And we haven't yet had that disaster. The temperatures have not yet quite got hot enough in Delhi to cause people to think, hey, we really, really do need to do something, or in Louisiana or Montana or wherever. But it's coming, and at a certain point, the consequences on agriculture, on electricity systems, on people's daily lives is going to be such that people will say something has gone very wrong and we have to act on this. So I think that's the plain direction of travel. It's a sort of slightly pessimistic version of optimism, but there you are. That's, I think, the way the law is going. Plainly, there's no question.
What do you reckon, Daisy? Do you think that would satisfy?
I think it's exciting. I think it's another tool that I think there are lots of different angles to solving the climate change problem, but law is going to be a really key part. And what you're saying about ecocide, I think is really exciting.
I think on ecocide, I will say, and I've said it before, with 100% certainty, at some point, the Rome Statute of the International Criminal Court will include a fifth crime. It is the only time in my life that our three kids, who are, in their late 20s, and sort of observe what I do, which I don't think generally is useless and boring, but when the Guardian newspaper said I was going to co-chair with a very distinguished Senegalese jurist a working group on the definition of ecocide under international law, our three kids WhatsApped me separately without consulting and said, finally, Dad, you're doing something useful. And I think that sends a signal that for that generation, this is where the interest and importance and excitement is. And I've got no question. You've really got to salute the youth of the world who got an advisory opinion on climate change to the International Court of Justice. Without young people, it would never have happened. It started with a group of young people in the Pacific. I'm about to head off to the Pacific and I'm going to meet some of them, and I'm really excited to meet them, to honour them and to praise them, because the old folks and the boring folks and the sort of settled folks sat on their asses and didn't do anything. And it took young people to stand up and say, this is not acceptable. And they changed consciousness, and they will contribute to an advisory opinion that is hopefully going to make some positive contribution.
So what's next with ecocide in terms of when do we expect it to become the fifth crime?
Well, it's on the agenda of the International Criminal Court now formally. It's before the Assembly of State Parties. 5 countries have said we need to amend the statute. There are about 124 countries that are parties to the statute, so you need to get over 60. So there's some work to do on lobbying. But, I go back to the work that I've done on the origins of genocide and crimes against humanity, and I remember, as I set out in my book East-West Street, the tales of Raphael Lemkin, a Polish prosecutor living in the US, going around the world and trying to persuade people to support this idea of a new crime of genocide, and people telling him he was ridiculous and he was a loser and he was a loner. And of course, 80 years on, the genocide hasn't stopped, but we have a convention and we have rules on genocide which allow people to stand up and say, this is not acceptable behaviour. And ideas really matter. In February 2022, I wrote a piece in the Financial Times at the request of the opinion editors, which proposed the creation of a special tribunal on the crime of aggression in relation to what's going on now on the territory of Ukraine, the wholesale Russian invasion of Ukraine. And 3 years on, last Friday, in the city of Lviv, to honour Lauterpacht and Lemkin, who both came from the city of Lviv, the foreign ministers of all EU member states met and announced they had reached an agreement on the creation of a special tribunal on the crime of aggression. Culture really matters in changing consciousness. Books, poetry, podcasts like this, films, all contribute to the change of consciousness that is followed by eventually a change in law. And ideas really matter. And putting ideas on the air in a podcast or on a piece of paper, in a newspaper article, can have consequences. And I think that's, as you say, Daisy, exciting, but also challenging.
And I think the example you just gave perhaps would encourage that movement to get support, to gather strength, because you can see appalling consequences on the environment from the crime of aggression too. What has happened to the breadbasket of Europe and possibly the world in Ukraine, the lasting effect of munitions and the apart from the releases, we'd had this discussion too, didn't we, Daisy, about the greenhouse gas consequences of war, right?
Yeah.
And obviously it's a peripheral thing when you're faced with the immediate threat of an invader. But ultimately, when you're reviewing what has happened and you're calling to account those who are responsible, it's perfectly proper that you should look not just at the effect on human infrastructure and human beings and the damage done to cultural artifacts, all of which are within the realm of the law today, but also the environment and the natural systems that have been damaged and the ways in which water courses and diverse systems upon which our agriculture are actually based, the pollinators, the whole series of things that hold the web of life together, they are also damaged by aggressors. And if culturally, philosophically, we can call those behaviors out and hold to account those who have power to have those effects, the law is the natural and proper place to first debate and then decide how to call to account those who exercise power in that way.
Absolutely, and I completely share that perspective, and it's grounds for optimism, I think.
Daisy,
watch the space.
Last word to you. What do you reckon, as a non-lawyer, as a scientist? And what do you think? Do you think it's a compelling case for the role of law to dealing with climate, or have we got more work to do?
I'm feeling optimistic.
Good. That's great. Well, why don't we bring it to a conclusion there?
I'm glad to have contributed to that. We haven't, of course, talked about the place of science in law, which is hugely important, and maybe that's for another episode. But I mean, it is remarkable seeing how international judges are able or not to engage with science. I mean, as a, again, positive way to finish. Until about 2014-15, I was pretty pessimistic about the capacity of international judges to deal with the complexities of science in relation to environmental issues. But my thinking completely changed when the International Court of Justice gave a ruling on a case brought by Australia against Japan in relation to the Japanese argument that it was engaging in scientific whaling in order to get around a ban on commercial whaling. And I was mightily impressed by the way in which international judges at the International Court of Justice grappled with the complexities of the science. What is science? Is this scientific whaling? The court determined what science was and said, no, this, what Japan is doing, is not science. And that, for me, was a real turning point. It was the first time I saw a group of international judges, actually led by our former teacher, Christopher Greenwood.
Chris Greenwood.
Did a really impressive job in court, asking questions, teasing out the issues. And that was the moment at which I thought, yes, we can put these kinds of issues before international judges with some level of confidence that it will be addressed in a decent way.
As Daisy said in the intro, environmental law broadly, not just the international examples that we've talked about mostly today, frequently requires understanding of scientific method, of how did these measurements take place, are they accurate, are they credible and comparable, and some tribunals that have been created specifically to deal with environmental issues include non-lawyers. There are land and environment tribunals in Australia, for example. There are specialist tribunals around the world that deliberately deal with this by ensuring that the decision makers are not just lawyers. But you do have to have confidence in a tribunal's ability to grapple with scientific method as well as evidence from a legal point of view. And when you have that, then you are much better placed. We are going to see a tremendous growth in different types of data too, that may or may not make it easier. Daisy, you mentioned AI before. Well, we know now that we can run these extraordinary processes to gather data from satellites, from LiDAR, from soil sampling, from all sorts of different measurements we never had before. And they're going to have to be interpreted, much in the way that DNA has revolutionized the criminal legal system and fundamentally altered decision making. We're going to get that with the environment for sure. And judges are going to have to be ready to take in all sorts of different forms of data, have them interpreted for them and understand them themselves in order to rule coherently on the legality or otherwise of the acts involved.
Very interesting.
Shall we call it a wrap?
Oh, thank you.
Thanks very much, mate.
So interesting.
That's great. Really good. Thank you for having me. Lovely to be on board.
Thank you so much for listening to Fossil vs. Future. Please subscribe to our podcast and give us a rating. And please follow us on social media. Let us know the questions that you want answers to or that you'd like us to discuss.